Okay, this is B450187. Counsel, would you like to make an appearance?
Yes, Jordan Garcia, bar number 12374, appearing on behalf of the plaintiff on an unbundled capacity.
Okay, and do you know the whereabouts of your client?
He's somewhere in the Midwest, I believe, right now. He's a trucker, so he's on his way to San Francisco right now. And where he's at after that, I'm not sure.
Yeah, I thought we had continued this for a time that he might be here. So that may have changed or not. No?
No, I don't. No, Your Honor, sorry. I don't believe that we said that we were going to change it for a time that he was here because his schedule is very
Erratic?
difficult. I mean, he doesn't know what he's doing from day to day.
All right. Do we have?
That's true. Yeah.
Okay. Do we have a phone number where we can at least get him here telephonically?
Yes.
Okay.
Yeah, we have. I'm not sure if we can get a hold of him. We can try.
All right. All right. And ma'am, if you could state your name and spell your last name for the record.
Jeanette Aguilar, Aguilar.
And you're representing yourself still, ma'am?
Yes.
All right. Counsel, they had reached a partial parenting agreement regarding joint legal custody and regarding a holiday schedule as how that would work out.
Yes, that's correct, Your Honor.
Now, did you have a chance to review that?
I have not, but from my understanding of what the plaintiff told me is that they agreed on everything, and when a signed mediation came back from the defendant, she'd taken out two parts that he had wanted, and he still wants those two parts in it. And that's my understanding of where the parenting plan is.
Why don't we see if we can get him on the phone? So, ma'am, do you have the number for him?
Yes.
What is that?
702-494-9442. Your Honor,
Yes.
there were a couple of other issues that were brought up prior. Can we also discuss that today?
We probably can. So, and we also have a case management conference that was set for today, counsel.
Hi, I'm calling for Ricardo. This is Sandra from Family Court. Hi, Ricardo, I'm going to put you on the speaker so you can appear at the telephone, appear through this one.
Sir, this is Judge Gonzalez. Can you hear me?
Yes, sir.
Okay, if you could state your name and spell your last name for the record.
Ricardo Aguilar, Aguilar.
Okay, sir, your attorney, Mr. Garcia, is present here in court, and Jeanette is also present here in court. My understanding is that the two of you had reached some type of a parenting agreement regarding joint legal custody and also a holiday schedule. Your counsel indicated that there was two items that may still be in dispute. So, ma'am, if you want to state, were there items that you wanted to take out?
I took out a part of it, or I did not want a part of it in there that stated that once he attains a job here in Nevada or in this area, that it automatically goes to week on, week off with the children, because we don't know when that might happen if he continues to stay working where he's working.
Okay, did you hear that, sir? She
Kinda. She doesn't want me to have them if I get a residency week on, week off.
That's what she's indicating. But the parenting plan is just a partial parenting plan. It only addresses holiday schedule and joint legal custody. To the extent that the two of you do not have an agreement, then we would have to hold an evidentiary hearing where you'd both come in, you would testify, you could call witnesses, and you would make a recommendation to the court as to what I should do regarding physical custody and visitation. Do you understand that, sir?
Yes.
And do you understand that, ma'am? Okay, so right now there is, as to the joint legal custody and the holiday schedule, are you both comfortable at least having that made part of the record?
The holiday schedule's fine. I don't understand the joint legal custody thing.
Joint legal custody means that the two of you both have the opportunity to participate in the major decisions in the children's life. For example, if there's a major medical procedure, you both would be able to have input on that regarding school issues, regarding education, regarding religion, the major decisions in life that the two of you would share equally in those decisions. That's what joint
She never allowed me to have that from the day they were born, so that one's out the window anyway. And that one,
Sir,
yeah.
the parenting agreement that you both entered into gives both of you joint legal custody. So,
Yeah, I've explained it to him, and it's probably best if you don't. I'll try to explain it to him
Okay.
again.
all right, sir, let me ask you this. You indicated, my understanding to Family Mediation Center, that you were going to try to fax your signature over on that document, correct?
I did fax it.
Okay, well, we didn't get it here. You're represented by counsel here in court, and so with your permission, I'm going to have Jeanette sign it. I'm going to have your legal representative sign it here in court, and then I will sign it, and that will make that part of an order. Are you okay with that?
I'm not sure. What I'm agreeing to what?
You're agreeing.
That my counsel is aware that I am not
Okay.
going to be active in any decision making in my children's lives as
No.
it has been since they were born.
I'm not. That's not what we're stating, sir. We're stating that you have a right to participate to the extent that you would like to in those major decisions. They'll be up to you, but you have that right.
I thought I always did, but I never do.
All right.
Yeah, I have the right. I agree to that. Yes.
Okay.
But I'm not going to get it.
All right, and you're okay with your attorney signing on your behalf here in court? This
She
is
can sign it, and she's not going to give it to me.
all right. That being said, then I'm going to go ahead and sign it. And as far as so, Jimmy, can you give those to parties for them to sign the original?
What does it mean when it's signed?
That it becomes part of a court order that's enforceable. So that means if she didn't allow you to participate as you would like in these decisions, that you could ask the court to hold her in contempt. Or if you, okay,
What's all that paperwork that we've already turned in? And
that's what we're signing, the stuff that you already turned in, but you weren't here, and I don't have your signature on it.
no, I mean all the stuff that I filed from July 29th till present. That's all supposed to. I'm supposed to know who their teachers are. I'm supposed to know who the contacts are, the people they hang around. I'm supposed to know when they are sick. I'm supposed to have decisions on
All right, sir.
discipline, raising them, but I don't.
Okay. This order that is being signed in court gives you a legal right for those items, okay?
How are you going to enforce that?
I'm a district court judge. I have a lot of power to enforce my orders, okay? If someone weren't to follow it, you would file a motion to hold somebody in contempt, but that's not today. Today we just need to have the order in place. All right, sir. You were also to complete a co-parenting class that you can do online. So if you're out traveling, you could go to a library and you could sign up online and complete that. Have you had?
Yes, sir. I've tried everything I can do on that, and I'm on a on-call basis, and internet is iffy at best at truck stops, and it can be up to an hour or 5-hour course, correct?
I'm not certain the exact length of how long it would take you to do online, but based on your, sir, hold on. Based on your personal circumstances and the fact that you're indicating that you don't have internet and you're on the road a lot, the court is going to waive that requirement as to you. The court would note that, ma'am, you've already completed that requirement and you filed it. All right.
I would like to go to a parenting class.
That's what that.
Together with her.
This is a co-parenting class that you were to take, sir. So you don't do that together. You do it on your own. So,
Yes.
needless to say, the court is.
I understood that they offer classes on parenting itself.
You certainly can do that, sir, and I would encourage it, but it's not an order of the court. All right.
Well,
So.
I really would enjoy it, and I would love it with her, and I could do that.
Well, co-parenting classes generally are not taken together, sir. And the two of you are in the process of being divorced, so you're not going to be living together either. All right. Additionally, sir, I had requested, and counsel, I don't know if you read the minutes from last time, he was to provide information regarding financial issues.
I saw the order, and basically I got the 2 pay stubs here that he sent me, he faxed me, that was put in the order from last time.
Okay.
If you want me, I can approach and hand you those.
Have you provided a copy to the other side?
I just got these yesterday, Your Honor.
All right, then what we'll do is when my marshal comes back, we'll have him make copies of those, and we'll give you a copy also, ma'am. And counsel, did you see a copy of her asset debt summary sheet?
I believe I have seen it, but
Counsel, if you'd like to approach. I'm going to give you one, and if you could give one to Aguilar there also. Sir, do you know when the next time you're going to be in town will be?
No, sir, I don't. Right now I'm on my way, and I'm behind schedule to be in San Francisco on Friday morning at 8 o'clock.
Normally, how often are you in Nevada?
It depends. I'm on a on-call basis. The company that I work for, we haul entertainment around the country, and it's on-call now, on salary, on-call, and I don't make any plans. And with the condition of my knee, I'm very fortunate to have such a job at all. That's good paying, it provides benefits that I'd like to offer her, the children, so that Jeanette did not have to worry about keeping benefits on the kids, and she could maybe get a better paying job for herself.
All right. This is my thought on this matter. Ma'am, my understanding you had filed a bankruptcy in November 2010, correct?
Yes, sir.
Did you get a final discharge of that bankruptcy?
Yes, sir.
Okay. I'm going to need to have you file. I don't need it today, but you need to do just a supplement to your either your motion or your asset debt summary sheet, and include that there, so I know that is discharged. My understanding is that the home went into foreclosure. Is that correct, ma'am?
Yes, sir.
Was that part of the bankruptcy also?
No, sir.
It was not.
Your Honor?
Sir, we're just having a discussion regarding some of the issues out there. You also indicated.
Filed jointly, and I was unable to be there when the trustees gathered, and so they filed on only her.
All right. Well, that's over with, sir. There's nothing I can do about that. As to you indicated that you had a student loan your last year of school, ma'am, that you had Pell Grants and other financial support to pay for your classes, and you're indicating that the actual loan was used for living expenses. Is that correct?
That's correct, sir.
And looks like there's some tools, there's some washer dryers, some other items out there. Looks like there's some musical instruments, and so what the court's inclined to do is, it's called like an A-B list, ma'am. What I would have you do is go through these items and prepare an A side and a B side. And what will happen is once you prepare the A side and the B side, what you try to do is make a equal distribution of the community property. So I'll just give you an example. Let's say the most valuable items on there are the musical instruments. Well, well, I'll give you a better example. Let's say you put all the musical instruments, you put the vehicle, you put everything, and the only thing that you put on the B side would be some dishware, all right? That would not be a fair and equitable distribution, because one side would get nothing and the other side would get everything. And the idea is that you would prepare an A side that is equally the same to the best that you can as far as value. And that way, if you had to choose, or if the other side had to choose which side that you would get, then you would make sure it's fair, correct? And so that's what I'm going to do. I'm going to have you prepare an A-B list. Counsel, I'm going to have you prepare an A-B list. As far as the debt that's out there, she's indicated the student loan is out there. There's also a small administration or small business administration loan. She's not as certain of the amount of that. But she's indicating the student loan was not used for purposes of paying for tuition and like, but actually community expenses. And if that's the case, then the court would order that they would share that equally. What I would like to do is keep the temporary order in place regarding the visitation, that when he's in town that he would notify you, ma'am, to make arrangements on that. And then I'd like to continue this for 30 days, counsel, so you could talk to your client and see if you can resolve this. I may even put it out 45 days. So what this means, ma'am, to the extent that the two of you come to some type of an agreement, either a complete agreement on the financials, an agreement on custody, if you have a complete agreement, counsel will actually prepare a joint submission. You wouldn't even have to come back to court, and we'd be done with this case. To the extent that you can't, then I want all the information on the financials as far as from your client on any debt that he's claiming that's out there, as far as what he believes is out there by way of personal property.
Your Honor, actually, I think mostly he would agree with this list based on what he's told me. This is pretty much.
Okay. And that way, and if not, then when we come back and we have an A-B list, we could probably resolve that on the return date if it's not resolved by the parties, and we'll just do the A-B list. And then if they haven't reached a final agreement on custody, then I'll just set it for a hearing on custody, probably sometime in June or July, and the matter would be resolved that way. Okay?
I have a question.
Yes.
Is the custody, I mean, since he's gone all the time, I have physical custody all the time. And when he comes to town, he's supposed to call or text when he's in town to see the kids.
That's correct.
Okay. So the parenting agreement doesn't...
The parenting agreement, the only thing the two of you agreed to was joint legal custody and the holiday schedule. There was no agreement on the physical custody. Now that may change. You'll still have an opportunity over the next 45 days if you can resolve everything. If you can't resolve the custody, then what we're going to do is I'll set it for a hearing sometime in June. And ma'am, you'll come in and testify under oath. You can have other witnesses come in and testify, and you can make a recommendation to the court as to what I should do. If I should just leave everything the same or change it, and then he'll have an opportunity to do the same.
Okay.
All right, so I'm going to put this out about 45 days.
That will be April 17th at 8:30 a.m.
All right, sir, what I'm going to require that you work with your counsel in good faith to try to resolve these outstanding issues. To the extent that you resolve them, then your counsel is going to prepare a summary disposition resolving all these issues. To the extent that you cannot resolve them, then in 45 days when we come back, I'm going to set this for an evidentiary hearing, and you're going to have to be here when I set this. And if you're not, I'm just going to proceed on this matter without your participation, because there's no way of me having a final resolution unless the two of you agree to it without you being here in Nevada. You understand that, sir?
You're asking me to negotiate a deal where I pay off her student loans and she pays off maybe a little bit
What I'm saying, sir, if those were community expenses that she used it on, then the two of you would share in that equally. She would have 50% responsibility. You would have 50% responsibility. If there's a small business administration loan out there, whatever that amount is, the two of you would share that equally. That's part of being married, that you share in the good and in the bad. What I'm asking to you to do, sir, is to see if the two of you can resolve these matters, and to the extent that you do, we're going to be done with court. To the extent that you don't, you're going to have to physically be in here and testify under oath so we can resolve these matters. Okay? So, that being said, I'm going to continue this 45 days. You can appear telephonically at the next one, sir, if that's necessary. If it's resolved, then you don't even, neither of you have to be here in court. You'll just submit it to me and I'll sign off on it. If it's not resolved, probably in June or July, sir, you're going to have to be here for a hearing. And then, counsel, I'm going to have you prepare an order from today.
Sure.
I have two other issues that I wanted to discuss. Do we still have time?
Okay.
The health insurance, that
Yes.
I am covering him on the health insurance. Is it at all possible that since he's been at this new job, he actually has health insurance available to him? Is there any way that he can get his own so that I'm not taking $100 out of my check each month for that?
Okay. Right now,
Not yet.
what I would be inclined to do on a temporary... Has he been paying you at least the child support?
Yes, and I had a question on that as well. Is it all due on the first, or because he makes two payments?
It's due on the first, but he's paying it bi-weekly.
Yeah.
Okay. Yes, I'm gonna. And then the cost to have him on there is $100, ma'am.
Approximately, I would have to look at. I have a pay stub. I would have to look at the exact cost of it.
And do you know, as far as that cost to have him on there, increases it, or is that just part of a family plan?
Through my job, I work for the school district. I'm covered. They pay all my expenses. They charge for a spouse, and the two children are charged for.
Okay. Do you know if there's an additional charge? Is it just a family part of it, or
I think it is per person. I would have to verify that with the insurance services at the school.
If you can verify that amount and just provide that to counsel, then I'll have him pay for whatever that amount is, or he can go out and get his own insurance. Okay, but in the meantime, until you get, written proof that he's actually going to be on some other insurance and he's asking you to take him off, you need to keep him on there, and he's going to have to. You just have to show that amount if there's an actual cost. That breakdown, and just provide it to counsel. And
Okay.
okay.
And one other issue is you had ruled the other counsel that he had said that they didn't want his per diem included in his income. Is that per diem not part of his income? I mean, I have daily living expenses as well. I don't get paid per diem for my living expenses. I mean, should that not be included as part of his income?
I tell you what, ma'am, to the extent that the two of you are able to resolve this, you can still resolve it. To the extent that you can't, at some point if we have a hearing, I can take that into consideration and I can apply it retroactively. Okay, today, as far as what we're on here for today, I'm not going to address that. But I can apply it retroactively, and I probably would. So you're aware of that, counsel. So
I understand.
That's something that could be in the final order if the two of you resolve it. Okay. So that being said, counsel, I'm going to have you prepare the order from today, and then we'll see you back here on.
April 17th, 8:30.
Am I to understand she wants to take me off the insurance?
Okay, sir. No. Wait. Okay. Okay, sir. What you should understand is right now, she's going to provide, if there's any cost for you to be on her insurance, that's something you're going to have to pay for. All right? She's not going to take you off the insurance until there's a written agreement from you that she can take you off because you have insurance on your own job. Once the two of you are divorced, neither of you are going to have any obligation to keep the other one on any insurance, and that's going to happen, if not in 45 days, probably within 3 months or so. The two of you are going to be divorced anyways. Right now, she's not going to take you off, but you are going to have to pay for it if there's a charge for that, okay?
I'm offering to put the children on mine, and
Okay, sir, we're not addressing that today. You can talk to your counsel and you can come up with options as to what best fits the interest of your children and the two of you. And if you reach that agreement, we're done. So, in the meantime, our return date will be
April 17th at 8:30 a.m.
Your Honor,
yes.
is the court aware that I have a completely torn ACL and a severe torn MCL, and
Yeah, I believe you mentioned that last time, sir. She's not taking you off in insurance right now, so you don't need to worry about that.
well, that's not the point I'm making. Is that I'm working and I'm providing gasoline, insurance, all kinds of extra money for the kids. Anytime she asks for it, she gets it. As well as when I visit and I can pick a drink at her convenience, I put in up to $50 to $70 for maybe tops 30 miles of driving it. And out of the guilt they lay on me, I go and take her to dinner. And she's got two college degrees.
Okay, hey, sir.
And
Right,
I'm
sir. Sir.
Okay.
Right now, the two of you are still married, and that's what married people do. They take care of each other, and they take care of their family. At some point, you'll be divorced, and we'll take it from there. But until you're divorced, you still have responsibilities, and even afterwards, you'll still have responsibility for your children, and probably as long as you're alive on this planet. So,
My kids always be taken care of.
April 17th, was it? At 8:30? Okay. All right. Then prepare the order, and we may or may not see you back here on April 17th. My hope is that doesn't seem to be a lot of issues outstanding that cannot be resolved. Okay?
Thank you, Your Honor.
You're welcome.
Thanks for your patience with my client, too.
You're welcome, Wilson.
One other thing, is it too late? I was seriously struggling with changing my last name.
You know, when you get divorced, ma'am, you can let me know what you want to
Because
do.
I had put it in there that I wanted to go back to my maiden name, but
That's up to you.
I can do it. a little
Either
bit
way, yes.
If I have more time to think.
Yes, absolutely. All right?
That doesn't include the children, does it?
No, the children are not changing their name. All right, so we're going to take you off record here, okay? All right, have a good day.